Hi, welcome back, everyone. Great to see so many familiar names joining us again. And of course, a warm welcome to those of you tuning in for the first time. We're going to give people just another moment to log in, so feel free to top up your coffee, silence those email notifications, and just get settled in for another session designed to help you stay ahead of that HR curve. For anyone joining us for the first time, I'm Kim. I'm the Director of Account Management here at HR Covered, and I'm joined by Darcy, our VP of HR Services, and the person who somehow makes compliance feel simple, practical, and even enjoyable. To those of you returning from previous sessions, thanks so much for spending another hour with us. You already know why we're here. We're cutting through that HR noise, helping you stay compliant with confidence, and making sure you leave with something you can use immediately in your organization. To our amazing clients, thank you so much for your incredible feedback from our last webinar. We love you guys. We love working with you. We genuinely appreciate all of you, and thanks so much for giving us some feedback and just letting us know what you'd like to hear next as well. Now, today's topic I know is a big one. A lot of people have been really excited to hear this one coming up. We're going to talk about workplace inspections. They are rarely enjoyable, often unexpected, and they can come with some real costs. So we're looking at fines, orders, even temporary shutdowns. Being prepared is the key to protecting your business and keeping things running without surprises. Now, we can't promise you won't get an inspection, and we can't promise it'll be as fun as this webinar, but we can help you get ready for it. So by the end of today's session, you're going to be walking away knowing why an inspector may visit your business, the essential compliance fundamentals everybody should know and have in place, what to do, what not to do when an inspector shows up, some examples of inspections that went sideways, because we don't want you to have to deal with those kinds of things. Let's learn from someone else's mistakes, and the real risks and consequences if you fail an inspection. So before we jump in, just a quick couple of notes. This session is being recorded. We're going to send the recording out to everyone that's registered. We'll cover all the content first. Darcy's going to do his presentation. And of course, we're going to save some time at the end for your questions. So feel free to drop them in the Q&A box at any time. That's it from me. Over to you, Darcy.
Thanks for the introduction, Kim, and welcome back, everyone. And to the new people that are new to our webinar series, welcome. This is a fun topic, and what I mean by a fun topic, it's fun to talk about. It's not fun to experience. So, but I know that we have a lot of people that join us to learn a little bit about workplace inspections. For our folks, our clients, especially from the United States, happy Thanksgiving. This is a great day to be joining a webinar. I'm sure you're not, because you're watching the football game right now. By the way, Green Bay is winning 10-7, much to our chagrin up here in Southwestern Ontario. But yeah, we're going to jump right into it. We have quite a bit of content that we're going to try to get through today. And there we go. And just gonna get this going up here. And we want to say that we find that our clients tell us that the most valuable part of our webinars are in fact the live Q&A after, because then we get to answer your questions. So I've tried to maintain the 25 to 30 minute parameter. This particular topic, Ministry of Labor inspections, and that includes inspections, and we're going to focus mostly on inspections, but we're going to differentiate between inspection and investigations. It's a lot. So because there's two different types of inspections, obviously, or investigations as it may be, which we'll touch on. We're focusing on the macro. We could dive in, we could do a whole hour on just ESA inspections, and then we could do a whole hour on health and safety investigations, and to a lesser extent inspections, but we're going to try and do a broader stroke. So here we go. I'm going to try to get this thing off my screen. There we go. Okay, so why is an inspector at your door? So a couple of things that we need to know and get clarified right out of the gate, because the stats are deceiving. And I think I noted that in one of my LinkedIn posts, and it wasn't meant to be cryptic or anything like that, that nature. It's just when we talk about inspections and investigations, what's proactive and what's reactive. A lot of what is actually proactive is actually reactive. They're not reacting to a critical injury. They're not reacting to a workplace refusal, but they are reacting to other factors, which makes you potentially a high risk employer, right? You're on their radar. So a proactive inspection, these are initiated by the ministry, right? These are not something where something happened, when you see there with the reactive investigation, where it's conducted in a specific response to an incident or complaint. So a complaint could be anything from I was terminated wrongfully, I wasn't given proper termination pay. I was not given, I wasn't paid out accrued vacation that carried over to the next year. They just did a use it or lose it on me. Or it could be something from the health and safety realm. It could be ergonomics. It could be a health safe, unsafe work environment for whatever the reason might be. It could be a critical injury, or it could be a work refusal. So there's so much here. Like it's hard to break down. So we're going to start to like kind of break down the difference between proactive inspections and investigations, just so you can understand. Because one of the clear takeaways we would like to see you take away from this webinar is, one, if you've had an inspection, why they're at your door and why they will likely come back. But two, if you've never had an inspection, what is it that they're looking for and how can you prevent it? So the best way to understand that is their criteria. So a proactive inspection, which accounts for the vast majority of proactive inspections, begging your pardon, are occupational health and safety. And that's just what it is, right? So when you look at when you start to look at the reasons that the Ministry of Labor or the Labor Board picks employers for proactive inspections, you'll understand why health and safety is the driving force. So just to give it a relativity, again, we'll get to the ESA versus occupational health and safety, but for every one ESA inspection that's done, you're going to have 10 of those. So if there was 100 ESA inspections done in Ontario, for example, last year, there would have been 1,000 occupational health and safety inspections. And when you see here, this is why health and safety looms large on the Ministry of Labor's radar. You're talking about high-risk sectors. One of those high-risk sectors that I specifically wanted to point out, because we saw it a lot this summer, and I think you're going to see it into the Christmas season with retail and what have you, is seasonal or vulnerable employees. So just so you understand what a seasonal employee is, obviously people that work during Christmas, people that work during the summer. But when you consider what they do during Christmas and during the summer, you're talking about forestry, you're talking about construction, you're talking about retail, things like that. And vulnerable employees quite often find themselves in some of those things. So vulnerable employees could be employees that are new to the workforce, so young workers, things of that nature, immigrants, older workers, et cetera, et cetera. So those are the things where you see a lot of Ministry of Labor enforcement, and hence you'll see those inspections. They're out there being proactive and looking for those companies that will hire those vulnerable or seasonal workers, and there's the inspections right there and there. So the other thing is, and if anybody ever goes on their jurisdictional Labor Board, Workplace BC, Ministry of Labor in Ontario, and they go on their websites, it's there for you to see. Every year, every jurisdiction will set out their blitzes. They will set out the actual areas, whether it be via topic or sectors, that they're going to be out looking at. And when they set out the sector, typically they tell you what they're going to be looking at. So for example, in the healthcare sector, a big drive in the healthcare sector has been on the muscle injuries. I can never pronounce it, it's such a big word. But well, anyways, you guys know what I'm talking about, hopefully anyways. But you'll see a big drive there, right? So you'll also see a big drive in the construction industry around vulnerable workers and a lot of immigrants on the workplace, and making sure they have the proper training and the proper tools and all that kind of jazz to make sure they should be there and they're safe while they're there. I highlighted the next three because a lot of the things, like when you talk about high-risk sectors, seasonal and vulnerable employers, blitzes, these are things that employers can't necessarily control. That's the industry you're in. That's where you're at. The inspectors are going to come. So you have to be prepared. You have to be a little bit self-aware, which makes you even more vulnerable. And again, the more of a necessity to have everything in place before the Ministry of Labor gets there. But for those folks, there's no excuse. You should know there's a high likelihood that the Ministry of Labor or the Labor Board or Workplace BC is going to show up at your door. For these folks, there's prevention, right? So we're talking about high volume of injuries or lost time. And a lot of people don't know this, but when the Ministry of Labor is looking at places they need to inspect, they're looking at your workers' comp numbers. They're looking at your WSIB numbers, right? There's a lot of people that think that doesn't interact, and that's just not true, right? So if you have a high frequency of injuries, there's a better than average chance that you're going to end up on the Ministry of Labor's radar. They're going to want to know why all those injuries are happening. They might show up at your door for an inspection. Even if you have a low frequency of injuries, but you have, say, in a workplace of 20, you have 2 workers who have been off for a workplace injury for a substantial period of time, which means they're likely to be more serious injuries. The Ministry of Labor is going to want to know why that happened. You're going to get an inspection, right? So that's important to know that these are things that are under your control as far as high volume injuries and lost time. And that is in fact one of the driving factors, especially when they say they do these so-called random inspections. They're not random at all. If you take all of these things that I just listed there, especially the bottom 3, that's 90% of inspections that happen in any jurisdiction across Canada. When they say random inspections, they're not random at all. They have things that they're looking for and they're showing up at your door. So repeat offenders, this is something I just want to touch on really quick. I'll touch the on the radar thing later, but repeat offenders, you got to know this. This is easy money for the Ministry or the Labor Board. They are a preventive branch, 100%. But they are a punitive branch when the preventive does not work. And when you become a repeat offender, you are a cash cow. They will continue to come back. It's not just that they want the money. They know that you're doing wrong, you're not fixing things, they're going to be coming back. So once you get on that proverbial repeat offender radar, you should expect frequent visits from the Ministry of Labor, which is why I always encourage my clients, if you cannot be on this train, do not get on board. Right? You want to stay as clear away from the Ministry of Labor. And if you do have an inspection, make sure you do everything right, get it fixed, do it ahead of the deadline they give you, and submit it before they have to come calling. And then they might leave you alone. Okay? That just means you've done your due diligence. And that's, at the end of the day, that's what every Ministry of Labor, Labor Board, every jurisdiction, they want to see. They want to be proactive. They want to see you respond accordingly. And then they know that you're a responsible employer who does their due diligence. Second part of proactive inspections is the ESA piece that I was just alluding to. Again, they account for a lot less than the occupational health and safety piece, just because you could see the factors that drive occupational health and safety are clearly defined towards that, that's where we need to be. So the things they're looking for in proactive inspections for ESA, public holiday and public holiday pay, vacation pay and vacation time, limits on hours of work and excess work, posters, record keeping, and a little bit of a twist. This doesn't happen in every jurisdiction, but certainly in Ontario, where we have the AODA, the Ministry of Labor inspectors, when they come out, have been asked in part to do to inspect your AODA requirements, which is, I'll get into it later with younger inspectors, but it's a lot to ask of inspectors who have been doing this for a long time and have a lot on their plate already between the ESA and occupational health and safety to be able to adopt all the knowledge that is required for AODA. Someone that's under 20 employees, someone that's over 50, et cetera, et cetera. It's a lot to ask. And you see a lot of mistakes. But again, we'll talk about that later. But these are the things they're looking for. There's a lot of things that employers do wrong here, right? So most employers don't know. And this is, and I could tell you this from experience, my almost 30 years doing this, but certainly my over 15 years doing this type of HR, most employers don't know that you have a responsibility, the employer, not the employee, to track the hours of work of your workers, to track the vacation time they take, to track the time they take off. A lot of people think that, hey, I have a salaried employee, I don't have to do that. It's not the case. If they're an exempt employee, there's certain things you don't have to track, but you still have to track, for example, vacation time. It does not matter. It does not matter if you have a PTO policy for a lot of our American friends and now our Canadian firms that are starting to adopt this paid time off. Take whatever time you want, no problem. You still have to track their vacation time. When the inspector shows up at the door, that's what they'll be asking for. If you don't have it, that's going to be a problem for you. Reactive investigations. So we're moving off the proactive piece and moving to the reactive. This is a little bit different. So with the reactive, you see with the proactive investigations, there's a large leaning towards the occupational health and safety side of things. With the reactive investigations, the majority of investigations are related to the ESA. And why that is? Well, let me tell you first that what they're really looking at is payment of wages, things that we just discussed, vacation pay, vacation time, termination pay, overtime pay, et cetera, et cetera. These are the things that people understand. It doesn't matter whether it's a white collar industry. It doesn't matter whether it's a blue collar industry. The whole point is that this affects everybody in every industry, regardless of whether they're high risk, seasonal, vulnerable, have lost time. It could be a small business. It could be a large business. These are the things that all employees are aware about because it affects their pocketbook. And these are the things that come to the employee, to the Ministry of Labor in the way of complaints. So that's why the majority of complaints that are made to the ministry are actually ESA bound. It's because people, when it affects your pocketbook, or you get terminated and you don't get termination pay, when you work overtime but you don't get overtime pay, or they decide to give you in lieu hours at equal time, which is in most jurisdictions not allowed to do, these are the things that the ministry get called for. So that's a reactive investigation. These are things where you doing things the wrong way within your business, and that's what we're here for, obviously, is to make sure you do things the right way and to be that resource for you. But you doing things the wrong way within your business, you are inviting the Ministry of Labor into your door, right? But now keep it in mind, even though that is a great deal of the cause for reactive investigations, which is ESA complaints, occupational health and safety complaints, or outcomes in this case, also account for a large number of investigations. Number one, first and foremost, harassment, right? And this is a big bugaboo for me, because harassment complaints, typically there are a lot of employees out there still, and the Ministry of Labor, the Labor Board, most of the time in my experience does a really good job with this, about turning employees away who do not follow their internal process, but there's still some that get through. So harassment is a very common occupational health and safety complaint to workplace harassment, sexual harassment, violence, to the Ministry of Labor, Labor Board directly. But you also see things like fatalities, critical illnesses, work refusals, health and safety complaints in general, which can be anything from a working alone complaint to illnesses to machine guarding, et cetera, et cetera, et cetera. Part of the reason that you see less occupational health and safety complaints relative to ESA complaints that require investigations, besides what I already mentioned. One affects your pocketbook. Occupational health and safety doesn't affect all industries. It does. Occupational health and safety exists in all industries, but in an office environment, the type of hazards you're going to face that will cause you to lodge a complaint against your employer for occupational health and safety is far different than that of an industrial environment, construction, healthcare, what have you. But in most cases for occupational health and safety, unlike the ESA, there is a process in place. So or an outcome or a bar that needs to be met. So for example, critical injuries, there's a bar that has to be met before you reach the level of a critical injury, which causes you to have the Ministry of Labor come in. Work refusals, there's a process. There's an entire process that has to happen before before two parties, the employer and the worker, cannot agree. And then only at that point, after you went through step one of that process, does the ministry get called in to mediate. So there are processes in place, which you don't really have with the ESA complaints. With the ESA complaints, the employer is either doing the right thing or the wrong thing, at least interpreted by the employee at a minimum. But for the most part, they're either doing the right thing or the wrong thing. They can lodge a complaint. The reason you see less occupational health and safety complaints, in part, is because there's a process in place which alleviates much of the reason in a lot of cases for the complaint to even come forward. Just waiting. So my computer must have had too much turkey today. So yeah, so complaints fundamentals. So it's a good slide because it's telling you what you need to do. These are things you need to have in place before an inspection, right? If you have these things in place and you get an inspection tomorrow, you have nothing to worry about. Matter of fact, there's a part of you that almost would welcome the inspector into the door just so they could check off the boxes and know you're a good employer and you could be assured they're not going to come back. But these are the things you need to have in place beforehand, right? So when you're looking at the health and safety piece, health and safety records, safety policies, training logs are important. Okay. I saw a question. I saw a couple of the questions that came in from the Q&A, and when there was a question about this, about training and due dates and what happens if there isn't a renewal date for training, what would the Ministry of Labor do in a case like that? It's an excellent question. I want to give it its own thunder there. So we'll get back to that. Incident near miss reports, equipment maintenance records, joint health and safety or representation documentation. All of these things you should have in place. And if the Ministry of Labor shows up at your door, you have nothing to worry about. From an ESA perspective, employee contracts, independent contracts agreements. Again, one of the most common complaints or investigations that came out of last year in most jurisdictions, specifically Ontario and British Columbia, was a misclassification between employees and contractors. This has been a big issue ever since COVID came in. And during COVID, there was a lot of people that were hired remotely. Employers wrongfully gave them the classification of a contractor, where in fact they were just an employee who worked remotely. So now the Ministry of Labor is in knee deep making sure that all those people that were misclassified, that were actually employees or were actually employees who were deemed contractors, get back to the point where they're deemed correctly. And this could be very costly for employers, incredibly costly. Because for all these ESA issues, for all these ESA complaints, whether it be vacation, overtime, misclassification, et cetera, the inspector or investigator, or the Ministry of Labor or Labor Board, as it may be, they have the right to go back, like it's fully within their purview, to go back 2 years. So if you have and in some cases it could go back even longer, but they have the readily right to go back 2 years where they say, oh, you have not paid vacation pay properly or overtime properly. So we're going to go back 2 years and then you're going to have to back pay it. This is in addition to any potential fines or other punitive applications that the ministry can provide to you. So, these things are very important. You can see them on the slide. And for those, I think Kim mentioned at the very beginning, this slideshow will be available to everyone after. So, if I'm talking a little bit quick or we're skipping through a few pieces because I noticed it's already 2:20, so I'm going to start going faster, then you'll be able to play this in slow-mo and start from there. The other thing you have to be aware of, in Ontario, AODA require policies, process, postings, accommodations, emergency evacuation plans. All of these things need to be in place in the Ministry of Labor or Labor Board, and it's that way for accessibility in other jurisdictions. These are things they're looking at too. So when you look at the things you need to have in place, this big three, health and safety, ESA, accessibility, these are things that should be done in place, and then you never have to worry about, one, your employees calling into the Ministry of Labor to make a complaint, or if it's a random inspection, you never have to worry about, being found at fault for anything because you're ready to go. Health and Safety Board and require postings. I'm only going to say this, and I'll tell you why on our last slide. This is so important. I've done my fair share of inspections. I've obviously been subject to or been consulted as an HR or health and safety expert, HR expert, begging your pardon, with some health and safety knowledge. But I've been brought in to be there when the Ministry of Labor there or the Labor Board. I've also done my fair share of inspections. I can tell you right now, that Health and Safety Board and required postings is a window. When you get a random inspection and you don't have this part right, they're going to rip you apart. Okay? This is the most basic stuff. The postings you need to have, what needs to be on your health and safety board, all that kind of stuff. The fact that you have a health and safety commitment that needs to be signed by the leader of your company or the head of health and safety in that company, and it needs to be done annually. If a Ministry of Labor person walks in the door and they see a health and safety statement, even though it's posted, but it hasn't been signed and updated in the last 3 years, open up the doors. Now they're coming in, right? Because that's an indication of where your compliance program is. So you got to know, if you leave with only one tip, Health and Safety Board require postings, you need to have this right. Because it gets, in certain cases, in random inspections, it will end right there. Okay. And I know this from firsthand experience because I've done it. I've walked into a building, I've looked at their Health and Safety Board, I've looked at their required postings. I said, all right, have a good day. See ya. And that's it. Because that is an indication to me as an inspector that is an employer that has it right. And I don't need to spend the next 2 hours making their life inconvenient. I'll just use that as a glimpse into their window, if you will. And shameless plug, if all this sounds easy, and it is easy, it's not easy, begging your pardon, but it sounds easy. But if you don't have these already in place or already developed, we provide complimentary checklists for both health and safety and HR to all of our clients. Anybody who's here on the call who's not a client, you can reach out to us. We'll reach out to you, what have you. We will provide you with a complimentary checklist for health and safety and occupational health and safety, or ESA, for each specific jurisdiction in Canada. So I know Kim will touch base on that a little bit later, so I'll leave it there. And I'll try to go a little bit quicker, and I apologize. There's just, I get a little ambitious too much and I put too much in the slides. So, but let's say the inspector's at your door. This is a pretty clear-cut slide, so I'll go into it relatively quickly. This is what you need to be doing, okay? you need to make sure in advance. And a lot of this is preparation. So when you leave this webinar today, make sure you have a meeting with your Joint Health and Safety Committee. Make sure you have a meeting with your health and safety person, whoever it is that does health and safety, and look at these slides and say, okay, we need to get this done so when an inspector ever shows up at our door, we're set. The first thing is have contact information available for the CEO, management, health and safety management, your external HR consultant, a lawyer if necessary. You want to make sure that if none of these people are in the building, that someone knows that as soon as they show up at the door, the inspector shows up at the door, because they're not going to wait for you. They're not going to say, oh, they're not here today. Can you come back tomorrow? Does not work that way. So you want to be able to contact them and say, hey, this is what's going on. Can you get your butt over here? Designated person. So this is probably even more important. And I have a little horror story to give you about this at the end, and hopefully we'll have time to get to it. Your designated person, in lieu of all these people being there, and a lot of times, those people are not readily available to be meeting a ministry person at the door. The designated person is the person that you want to make sure that if somebody shows up at the door for inspection, that's the person they're talking to. Ideally, it should be someone on your Joint Health and Safety Committee. Not necessarily, but ideally. But you want to make sure they're prepared. They have the health and safety knowledge necessary. And what I mean by that is you should make sure that they know what the inspector is entitled to, and in certain cases, and it's very limited, what they're not entitled to. So they need to know that so they can be your representative, but they also have to have soft skills, right? And that's going to go to the very next point. Be nice and cooperative. You are not in control here. If you've ever been pulled over by a police officer and you ever tried to lip back at them about why you thought you were getting pulled over, how did that work out for you? Right? So it's the same thing here. There is nothing to gain at all by being anything less than nice to the employer. And the last thing you want to do is give them the indication that you were all are not cooperative, because that definitely won't go well for you. By the way, that's a potential fine by itself. So being non-cooperative or being obstructive in the process, very rarely do you see it. It's just, and because they'd have to prove it, they have other ways of doing that. In other words, giving you a copious amount of orders with a little bit of time to get it done. So being nice and calm and cooperative it sounds like common sense, but honestly, I have one of my own stories I'm going to give you where I was not nice, kind, or cooperative, and I can tell you what happened to me in my youth. So I had to learn that lesson the hard way. This seems like common sense, but I guarantee you the majority of people that get inspected don't take notes. When the inspector's walking around telling you what's going on, take notes so when they ask you questions later, you can refer back to it, be able to be prepared to be helpful, all these different types of things. It also helps you when you get to the point, if you're in a position to negotiate about an order or to negotiate about a time frame, it gives you that substance. It allows you to look back and say, hey, listen, you're asking me to do this, this, and this, and that's a lot. I know 30 days is the order, but is there any way we can get that extended, right? So taking notes is important. And for God's sakes, people, if you see a ladder leaning up against the wall when the inspector's coming through, for example, or a cord that's underneath someone's desk right next to their chair, while there's inspectors there, move the ladder, move the cord. Honestly, it always befuddled me that when we do inspections, or I'd be there as a consultant and the inspection was being done, that there were all these really minor infractions and the inspector is walking right by them and writing them down. Doesn't have to go in writing. We never see an order. We never even get mentioned in the report. Go and move the ladder, go and move the cord, help yourself just a little bit, right? And then you can help yourself a lot. Be proactive. This is one of the things that I actually am a big advocate of. So again, one of those key takeaways here, when you leave this webinar, there's certain things that inspectors need as a basis, right? So you're looking at the health and safety board, the postings, your policies in your training, your logs for your training, things like Joint Health and Safety Committee minutes, any orders that have already been provided, all those different types of places, violence and risk assessments. These are things that inspectors are looking for at its core. Don't make them look for it, right? When the inspector gets there at the door, say, you know what, happy to cooperate. Let me start getting some of the things that you're going to need. They will appreciate it. It shows that you're doing your due diligence. It shows that you're confident about where you're at. And if you're not confident where you're at, then that's another problem entirely. But if you've done everything that you were supposed to do in the last slide, this is a great time to show it, right? And again, if it's a random investigation, there's no set criteria for how many things or steps that inspector has to go through. You could do this, and that might be enough for them. They walk out the door, they shake hands, and you're done, right? So that's a super important thing. What happened? Why? Don't know why that happened. Okay.
That's all right. I'll come back if there's nothing more.
I know, I just don't understand it. That's a new one. That's never happened to me before. It's like karma kicking me out, saying we're done. You spent too much time with us. Really quickly, because the last slide's a little bit funny too, or not funny, but it's salient tips. Contact information. Did we do this already? Yep, we did. Inspectors at your door. So this is part B. This is a more this is, I think this is for more, this is more detailed information that you might want to take away from what you might need to do if there is an inspection. Employee files. You got to know, and this is it's a thing that most employers, I think, know, they just don't do, and I don't know why. It's the first point. The inspector is likely going to want to see some employee files, or at least some examples of how you set up your file, make sure people are getting paid properly, make sure that it's noted in there that, when you look at a pay stub, that vacation pay is paid out on a different line, all these different types of things. These are minor things that the employer looks for. One of the things that an inspector will slam you for is if they find medical in the personnel file. Medical is confidential information. It does not go in the personnel file. There should be one person in your organization that has access to medical information, and then there should be a second person who would be a designate in their place. Ideally, it would be locked up in a separate filing cabinet or in a separate spot in your computer that only those two people have access to. In theory, you could have one of those Dewey Dang folders where there's, like, if you're old school, where there's folders in it, you could have a personnel file, and then behind it have its own separate medical file marked confidential, right? And the only people that should have access to that filing cabinet are those two people that I mentioned. This is often overlooked. The ministry looks for it. It's something you have to know, right? And then the other piece too is, and this is important, especially if it's an investigation, and the reason they are there is because of an investigation, is if you had a lawyer conduct that investigation, that is solicitor-client privilege. That needs to be clearly marked on that file. The investigator does not necessarily have the right to access that file. So if you get in a case like that and it's clearly marked in that file, and the person who is the person heading the investigation in your part is there and knowledgeable of that, if they demand the file, you can actually ask for time to speak to your lawyer, right? Now, it would have to be reasonable, but these are things that you need to be, again, a little bit higher end advanced tips, but these are things that you need to be aware of. Requests for discussion, again, this will depend on your knowledge and your comfort level. If you've been able to build a rapport, and because you've been calm, nice, and cooperative with the inspector, when it gets to the point of, making out orders, ask if you can chat about it, right? There's nothing wrong with it. Honestly, it'll work sometimes, it won't work other times at all. You get a lot of these younger inspectors that came out of COVID who, quite frankly, I've had more than my fair share of arguments on behalf of my clients for. That's my job. Don't you do it. That you just don't do it. It doesn't work well for you because you're the person getting the paperwork. But some of the younger inspectors just don't respond to that type of cooperation. Some of the inspectors who have been doing this for a while and want to see you do well. At the end of the day, they don't want to fine you. They want to see you do well. They're very open to having discussions about what those orders are going to look like and what they're going to entail. Same thing with timelines, right? You can advocate for timelines if you know there's going to be a lot of information there and it's going to take some time to get. You can actually advocate for a longer timeline. You can also ask for extensions of the timelines in the process. Just don't ask for it the day before it's due. That won't go well for you at all, because not only will they prejudice against you, in other words, they won't give you the extension. When they give you any type of penalty, they'll think you completely ignored the order for the last 29 days, and on the 30th day ask for a mea culpa, and they will penalize you harder. And that's just human nature, and it's the way it is. It's actually the way it should be, to be honest. And if the outcomes are serious, that lawyer or the CEO or that HR consultant or even health and safety consultant, beg your pardon, that you have on call, make sure you get them on the phone right away. If they can get over there to be there to kind of soften the blow, that would be great. Any type of things you could do to mitigate the damage before that inspector writes that order and makes the referral to a judge, that's something you definitely want to be doing. Last slide, really quickly. Okay, so these are actually some of these things we've already talked about. Tips and stories, I've already talked about this. The Health and Safety Board postings is it's the window. Again, these inspectors, they're coming in, they're trying to get a glimpse of whether you're diligent, whether you're compliant or not. A lot of times this is enough for them. right? If they can go to an extra place on their list and get that done and feel pretty confident that you are in a good place, and they could show by what you've shown them, which is your health and safety and postings is the first things they're going to look for. They can tell that, you know what, you're doing your due diligence. At the very least, you're doing your best. A lot of times they'll walk out right there and then. Stay off the radar. Okay, so we talked about this again. High volume injuries or lost time. These are things you can control. I know you might have a great health and safety program. That's the claims management, disability management, getting the appropriate medical, getting people back to work faster. All these things are things that will bring down your lost time numbers. And in certain cases, depending on what you're doing with your health and safety program, lower your frequency. Okay, repeat offenders, aligning with, this is a controversial point, I'm going to say it anyways, aligning with other government agencies and supports. It is a fact. And the numbers vary depending on what information you read. In between 30 to 40% of businesses in Canada are known to the various jurisdictions, labor boards, or Ministry of Labors. In other words, they don't know who most of you are. If you want to get known by who you are, go and sign up with another government agency and voluntarily give them your information. I've always been at odds with this. I started out with workers' comp in Ontario. I've always been at odds with this when they said, okay, when you sign up with a workers organization who would give you deductions on your WSIB premiums and all that kind of stuff, who gets that information? Who gets the information about you signing up and all this kind of stuff? And in fact, it can be shared in certain circumstances. It's not supposed to be, but in certain circumstances, it can be. Stay off the radar. Do what you want with that. AOD accessibility, pay equity, pay transparency. When I talk about the 30 to 40%, the government knowing what you are, all of these things are self-reporting. So this is a conscious effort by the government to be, one, more efficient, rather than having to do actual inspections by a physical person on site. It's more efficient to have you self-report and then they look at it that way. But it's also a way for them to find out who you are, right? It's also a way for them to get you into the system. Now you're there. So you have to, basically the long and short of that last 2 points is, if you've never been inspected before, that's one thing. But as the government progresses with the different ways they do things, they are finding ways to put more people in the system, to have more accountability, which is a good thing. It's a good thing for those employers that are doing what they're supposed to be doing, and for those employees who come to work every day and don't want to be hurt, right? But you have to be aware of that as an employer. Be calm, be very nice. Even if you have it, and I've been in this more than a few times, where you have an inspector where you know they're wrong, where they're interpreting something and they're seeing something differently than what you believe it should be interpreted or inspected. Now, that's not the time to fight. There's a saying in union relations, work now, grieve later. Just, make your objection known. Say, but you know what? We respect your authority. Get your order, send your appeal in. Most appeals, depending on I will say appeals are very effective with the Ministry of Labor and the labor boards across Canada. Another webinar. That said, try to advocate. Like I said, you want to be nice, but at the same time, you want to be nice to the inspector, advocate for, discussions around the orders, timeframes. You also want to be very nice to your Joint Health and Safety Committee. One salient point, a lot of our clients, a lot of the people I've met in HR over the last 30 years, think the Joint Health and Safety Committee is a pain in the ass, right? And that might be a very good case. But that same Joint and Health and Safety Committee member is going to be the one that the inspector asks to walk around with them when they're doing the inspection. And this person and the job they do that you think is a huge thorn in your side, that you might have even disrespected at times, is the person that now has the ear of this inspector for the next hour. So think about that the next time you approach your Joint Health and Safety Committee and how much respect and latitude you want to give them. Just saying, do what you want with that information. And a few stories, I don't even know if we have enough time for any stories. I'll just tell you this one. Government organization, not going to say who, workplace, the Ministry of Labor showed up at their door. The person there is called the CAO. CAO couldn't make it in. The inspector said, well, I need this information. You're the health and safety rep. Just give me the information. The person refused to do it. Get the CEO on the line. CAO said, I'll be within an hour. Hour later, he called up and said, I can't make it in today. Half hour later, they showed up at the front door with U-Haul trucks, took all of their filing cabinets, locked them up, lock and key, put locks on the front door, shut the place down for 3 days. That's how that works. Okay, so just in case I have more stories, but we don't have time for it, so another time. But just in case you're wondering how much authority, when you look at the authority that a police officer has relative to an inspector, I would say an inspector has more authority when it comes to things like search and requesting documents and reason. Like they don't, anyways, just be compliant. cooperate, be nice. That's a takeaway. And yeah, on that, that's my dog, Tar Heel. He's the HR covered mascot. He has his own LinkedIn page, Tar Heel. You got to join it. He sends out really cool stuff that's HR happy all the time, and he's cute as hell. And he's been very quiet right now, so I'm very appreciative of that because the last webinar I did, not so much. And anyway, I'll turn it over for questions. And thanks, Kim, and thank you, everyone. I hope you took something away from that that's useful.
Perfect. Thanks so much, Darcy. We need a bigger picture of him for next time. I love him. Well, that was fantastic. I always walk away from these webinars with at least 3 new aha kind of moments, and I feel like I got 4 out of this one. So that was great. I'm sure everyone watching feels the same. We know HR can get complicated real fast. Every organization has its own quirks and challenges. Figuring out the right way to move forward, sometimes it's a little overwhelming. And I mean, as Darcy just went over there, the stakes are real. Getting it wrong costs you time, money, and a whole lot of stress. So, having the right kind of support makes all the difference. We appreciate you coming to these webinars to learn more. But if you do need more at HR Covered, what we do is simple. We protect your business, save you money, and help you get fast, affordable support tailored to you exactly when you need it. Everything from HR, health and safety, through to hiring, recruitment, even legal support, we've got covered for you. Today, Darcy mentioned we do have a little bonus for you. We have a free compliance occupational health and safety checklist, either or. Whether you're a client or just checking us out, we'd be happy to walk you through them as well if you want to set up a meeting with us. Absolutely no charge either way. The easiest way to reach us is service@hrcovered.com. Don't be shy, even if you just want to reach out to tell us how much you loved this webinar. We would love to hear from you. So after that shameless plug, I'm going to jump into questions. Just quickly though, because I do see a lot of questions are asking, as an HR Covered client, do you provide things like what are the posting requirements, that sort of thing? Absolutely, we do. Just reach out, service@hrcovered.com, and we can help you out with that right away. Okay, first question. Does an inspector have to have a reason to show up at a business?
Technically, no. If you're a business in Ontario, these are the requirements that you have to uphold to be able to do business or business in any jurisdiction in Canada, begging your pardon, and sorry to everyone outside of Ontario. There's requirements in every province. You're held accountable to those. They can show up at your door for any reason at any time.
Okay, wonderful. Next question. We pay all of our employees via salary, so I assume we are not subject to tracking hours or vacation time, that sort of thing. Is that true?
No, it's not, unfortunately. And this is a common misnomer. So I'm glad someone asked the question. I think I touched on it on the presentation, but I know a lot of these questions come in prior or after. You are required to track the hours of work, break time, vacation time, all that kind of stuff. In some jurisdictions where you get paid sick time, you're required to track sick pay. This all has to be done regardless. When you are in exempt status, so an exempt status, another misnomer. Just because you get paid salary doesn't make you exempt. You're a rank and file employee who just happens to be paid via salary. It's a method of payment. It's nothing more. What defines you as different is whether you're a manager, an employee, or certain types of professionals listed under the different jurisdictions. And if you're not one of those things, even if you get paid salary, you have to track their hours of work, overtime, vacation pay, all that different kinds of stuff. Even if they are exempt, you're still required to track their vacation time, their sick time, if there's paid vacation, paid sick time in that jurisdiction, et cetera, et cetera. So, and that is something that the governments make a lot of money off of, because most employers, in my experience, don't do that ritually.
Yeah, no, that's so true. It's funny. We've put out a time off tracker. If you're a client here, I'm sure that you've probably already used it, but so much more handy than going through notes. It's not always easy to keep up with this stuff. Okay, next thing I've got here is, does an inspector or an inspection or an investigator need a warrant to look at confidential or employee information?
In most cases, no. And that's what that's what I was kind of alluding to when I mentioned about the police officer. And, like when you talk about border security and you talk about police officers, and then you talk about, Ministry of Labor officers, you'd be surprised, because they have these niche powers, that they're just, if they want to be there and they want to see all of your documents and all of your policies, they want to be able to walk around your workplace, test your machinery, literally get somebody to get on a crane and work the crane for you, or, work a medical device, they can require that you do it. There's a few cases where that is not the case. For example, the solicitor-client privilege piece that I spoke about as it pertains to a file where a lawyer was the one that actually conducted the investigation. And even then, there might only be parts of that file where advice was provided or recommendations were provided that the inspector is not entitled to. The actual investigation itself, even though done by a lawyer, the investigator might be entitled to without a warrant. So it's very important that you understand. It's important that whoever's meeting them at the door understands that salient point. They're there, they have the authority to get what they want, so you should give it to them.
Okay, wonderful. Wonderful and scary. But if you do have questions specific to you that we can't get to today, please do reach out to us as well. Hold on a second. My understanding is that some of the required training for employees does not have a date which we have to make them retake it. If we have not trained our employees for a few years, is the inspector going to say we're okay or not?
That's a great, I alluded to it because I knew that question was there from before we even started. So, and it's a great question. And I get it relatively often. I know you get it, that your team does as well, Kim.
Absolutely.
What the labor board and what the Ministry of Labor are required to do is hold you to the bar of due diligence. So I know that's like a catch-all phrase, but at the end of the day, the requirement for training in any jurisdiction is not that you have taken it. It's that you understand it and can apply it. And it doesn't matter whether you took the training 2 weeks ago or 5 years ago. If you can understand it and apply it, you're fine. So what a Ministry of Labor official or labor board official will do, and what I've done in the past, is I've literally said, I need to speak to 4 employees one at a time. And I said, okay, we're going to talk about workplace violence and harassment training. Can you tell me what workplace violence and harassment is? Can you tell me what you would do in the case that you experience workplace violence and harassment? Can you tell me what the next steps were for, all these different types of things? If I get from all 4 employees, for example, that they can't answer these questions, I don't care if you took training 2 weeks ago. I will give you an order that everybody in the workplace has to do it again. And then I'll go back and look at the training that you're providing or using and saying, why can't any of these people remember it? You putting we used to always get this thing about, we're just going to let them read the policy and that's the same as training. There's a difference between training and education. The training has to be done in such a way that it's effective, and if it's not effective, it's not compliant. So these are the things. Is best practice once a year? Is best practice to give training once a year? Absolutely. Would I suggest that because human beings are the way they are, they don't retain things, especially things that they don't want to retain, like health and safety stuff often. But do you think that it is reasonable for all of your employees to retain something after a year or 2 years? No. So that's why best practice is every year, but certainly I would never recommend to an employer that they not retrain after every 2 years, because if the Ministry of Labor comes in, they'll be not looking at your logs. They'll be looking at, they'll be actually asking your employees if they can retain and apply the knowledge accordingly.
That's great. And I always hear from our clients, the employees they ask are always the ones you really, really don't want them to ask, right? So we got to make sure they're all good. What is an inspector looking for when they're called because an employee is unhappy with the outcome of an investigation report?
That is a great question. Because one of the things that I said I got frustrated with earlier was they've been pretty good about this, is that when you have a proper investigation or harassment, violence, sexual harassment policy in place, you're required to go through the employer. You're technically required to go to the employee who harassed you, but in a lot of cases that's just not doable or safe. So you go to your employer, and a lot of people skip that step and go right to the ministry, and the Ministry of Labor Board should rightfully tell them, go back and follow your process. And if that doesn't work out, you can come back to us, but you have to follow the internal process. But when they've done everything they're supposed to do, and it gets to the stage of investigation, and let's say the respondent didn't like the outcome because it wasn't to their favor, and they go complain to the Ministry of Labor, the Ministry of Labor isn't there to make them happy. The Ministry of Labor is there to look at the actual process that took place. So they are literally going to look at, was this investigation appropriate in the circumstances? And what that typically means, it means a lot of things, but what it really means is, was the person who conducted the investigation unbiased, at arm's length, qualified to do the investigation, aka good knowledge of the act and knew how to do investigations. And then they will look through the rest of the process and make sure everything was done properly. If everybody that was named as an interview was interviewed, was all the evidence collected that should have been collected, so on and so on. If all of that was done properly, they won't look at the outcome. They don't care. They're only looking to make sure that the person that did the investigation was an appropriate person to do it and that everything was else done properly. If it was not done properly, or in the majority of cases when this happens, it was an internal investigation where, a complaint was made against a CEO or a manager or somebody, which means anybody who does the investigation is under that person, which makes them inherently biased in most cases, then they will say, okay, this is not an appropriate in the circumstances investigation. We are ordering you to do a third-party investigation, and you will pay a lot of money. Even when we get referrals for third-party investigations ordered by the Ministry of Labor, we charge more because we know the Ministry of Labor is going to be looking at it. We always do an investigation like we know there will be a third set of eyes on it, but when we know there's going to be a third set of eyes on it, that's a little bit different, right? So it's really important that when you go down the investigation route, that you're cognizant about choosing the right person and making the right processes followed, because even when you do everything right, the Ministry of Labor is always there as the backstop for an employee if they didn't like the outcome.
That's interesting. Okay, all right, let me get to the next question here. Can you appeal an inspector or investigator's ruling if you disagree with it?
100%. And you will find that when you have good cause for appeal, then typically you wouldn't appeal unless you have good cause. And this has a lot to do with the influx of young inspectors since COVID across Canada. And it's what it is. I know they do 9 months of training and all that kind of stuff, but at the end of the day, wisdom is wisdom. One of the horror stories I was going to tell about how I made a stupid mistake when I was 5 years into the job in health and safety. I made a stupid mistake with the inspector, said the wrong thing, ended up with 32 orders in 30 days to get them put in place. A lot of work, my fault. Didn't think it was my fault back then. No, it's my fault right now. But a lot of these young inspectors, they're working their way through. Only experience and wisdom will give them the time to make good interpretation. When you go to an appeals process, you have a very there's a better chance than not that you will be successful, at least in some breadth of what you're asking for. That's the time, if you're unhappy with the inspector, to bring it up, not with the inspector at that time. Make your objection known, wait for your opportunity to appeal.
Okay, yeah, that makes sense, definitely. Does the employer or manager on site have the right to accompany the inspector when they're on our site?
Yes, that's relatively status quo. Not always though. An inspector has the right to say, no, I'm doing this. The only thing that you should know, and this goes back to a point I made in my slide, the inspector will almost always, they're supposed to, matter of fact, go to find a worker member, not an employer member, a worker member of the Joint Health and Safety Committee or the worker health and safety rep. That's who they want. They're not interested necessarily in having the employer member there or an employer representative. Most inspectors are pretty cool that way because there are questions and information they're going to need. So they're going to need to be able to go to somebody to get it. But there are some senior inspectors that I've worked with over the years that will literally say, I will come to you with a list of what I need, or I'm going to provide you a list of what I need. Can you go get me your Joint Health and Safety worker member? And we're going to go for a tour while they're collecting the stuff they need. So you have to that's why I said, be nice to your Joint Health and Safety Committee people, because that's an hour with the inspector. And if you weren't nice to them,
I love that. And I'm a Joint Health and Safety Committee person, so I can't hear that enough, right?
We love you here, Kim. You're so amazing. You're great at your job.
Oh, stop it. All right, next question. How long are we required to keep employee records after they're no longer with the company?
Great question. Because that's a lot of companies do it innocently. They get asked for these records, but they don't have them because the employee quit, let's throw them in the garbage, right? Or whatever you dispose of them. You're in almost every jurisdiction, it's 3 years. Now, do I think that's best practice? Absolutely not, because the CRA can demand those types of records up to 7 years after the fact. So when you consider the types of things that they're looking at, like overtime, hours of work, vacation pay, things of that nature, all things that dive into the realm of the CRA, they can ask for that information 7 years back. And in lack of information that you provide them, they'll use what they have, which might mean employee provided information, which might not be factual at all. So my best practice, and again, with computer files, it's a little bit easier than it is with paper files. So it's not a biggest issue any day. But my recommendation to all employers in every jurisdiction is to keep your files from 7 years from the date of separation. But 3 years is the number in almost every jurisdiction.
Wow, and that comes as a little bit of a shock to me, but it totally makes sense the way that you're saying it. So hopefully nobody's panicking too much there. Don't worry, we can help with some things, right? Does HR Covered provide a service where they do pre-inspection audit for clients? I can actually take this one, Darcy, and give you a little bit of a break on your voice there.
Sure.
There's actually two ways we do it. So depending on how involved you want to be, if you're a client or not, we can kind of go through like a couple things with you just to have like almost like a working with you sort of an audit of the basic things that you need to have in place, both for health and safety and for HR compliance. It is high level. If you want someone to go through and look specifically through your policies, through your processes and documents, and looking through everything exactly the same way an inspector would, we can do that. We can flag any issues, provide clear recommendations, and you can get real full coverage that way, where we've got eyeballs on every single little thing looking at it. Usually we would do it remotely, but there is the option also to do it in person. So yeah, that's definitely something I would say. Reach out to us if that's you and you need help there. service@hrcovered.com. Okay, moving to the next question here, and I'll let Darcy do this one because I'm not that great at answering questions. Can a workplace investigation lead to criminal or civil charges? And follow up to this question, does the investigator have the authority to make that decision?
Right. So an investigator can make a referral. So inspectors typically don't make a referral. Inspectors will typically refer to an investigator. So if it's an inspection and they find something, wrong or what have you, or they give them an order and something hasn't been corrected, at that point, typically, not always, it'll get kicked to an investigator. So an investigator, whether they be coming in as a point of origin, like for a critical injury or something or the other, or being referred to by an inspector, they have the power after the investigation is concluded to make a referral to have that looked into. They themselves do not have that power. They themselves. So yeah, I think so. But in reality, in many cases, and I say this in credit to many of the senior inspectors that I've either worked with at one point, or just to many of the senior inspectors that I know over the years. Some of these guys and gals are excellent at what they do, and they're going to be better at determining whether something was an issue than maybe a police investigator or somebody else. So if they're at the point where they're ready to make a referral, you need to be on the phone with a lawyer.
Yeah, that's very, very, very good advice there for that one. Okay, next question. We had an employee go to the ministry regarding a workplace harassment complaint, and they intervened. We argued that the employee did not follow the process and the policy, which we are required to have by the ministry. Do we have any rights here?
Yeah, that's I just talked about that in the last one. So sorry, I answered this question with the last one. That I would be do whatever the Ministry of Labor or Labor Board wants you to do, but I would certainly be going back to the Ministry of Labor or Labor Board and not lecturing them, but just making them aware that it is our information and it was our expectation that we have a policy in place, that a process is being in place, that process is mandated by the Ministry of Labor or the Labor Board in said jurisdiction to be followed before the Ministry of Labor or Labor Board intervenes. In other words, you overstepped. That's not their role. That they have a right to be involved at a certain point, but no different than a work refusal process, right? The Ministry of Labor, the Labor Board, does not come into play in step one of a work refusal process. That has to be completed to the satisfaction of both parties, or at least the employer, and to the satisfaction of the minister. And then at that point, they get called in. Stepping in early it's not good for lack of better words. So yeah, you might want to suggest to them, well, can you at least encourage them to go through our process first so we can handle this internally? Because the other outcome might be that they have an investigation ordered by a third party for them, and that's just an unfair outcome for the employer in that case. So hopefully that helps. And if this was recent, and this is not a question from the past, if this is a recent question, hopefully you can get a resolve with the ministry on that one.
And I'm just going to put in a little plug here. If you even start having a hint of harassment coming on the horizon, reach out to us right away. The right away help that we can give you is so crucial to, we can always do cleanup, but cleanup's always a little bit more difficult for everyone involved, right? I think we have time for one more question because Darcy answers so darn quick, so we should be able to do it. If we haven't got to your question yet, don't worry. We're going to keep them here on file and we will reach out to you. Of course, you can always reach us as well, service@hrcovered.com. So the last question that I have here, our employees are all remote. Two questions. If there's no physical workplace, are we required to have workplace postings? And can an employee have their home workspace inspected?
Good questions. We got a lot of that during COVID. We haven't had much of it lately. But yeah, anyways, yes, you're still required to have postings. You're still required to have policies. You're just going to make them electronic or virtual, right? So if you have some type of share platform, or even if you send it to them via email and instruct the worker, say, we'd like you to make a folder on your worktop that basically says, required postings and training and all these different types of things, tell them to put it in there. But they technically have to, like the workers' comp or WSIB poster, they need to have that. The occupational health and safety poster, the poster when they first start working, your employment standards rights, AODA postings, all that kind of stuff in Ontario, and accessibility in other jurisdictions. All of those they need to have. As far as inspections go, this is interesting because it is your workplace. But the actual inspector, like a ministry inspector, they recognize it as a workplace for the purpose of everything except the ability to enter said workplace to do an inspection, right? An investigation, I'll be honest, if there was a critical injury in someone's home workplace, I would be curious to know if the Ministry of Labor Board, now I'm going to actually look into it because that's what I do. I can't do that alone. But in an investigation, there's a possibility. I'm sure that might be the case, but an inspector can't go into someone's home to do a workplace investigation. That said, when you're doing your monthly, quarterly, what have you, you should be giving them home checklists. Everybody on this call, like if you didn't know that, you should be giving them home workplace inspection checklists where they literally have to submit it, check off any wires, like a checklist of what they should be looking for. Do I have access to a fire extinguisher? Do I have another way out if I can't get through the door? All these different things, ergonomic stuff, blah, blah, blah. So that's something that the Ministry of Labor may expect of you, that if they come in and you have a worker working remotely, have you been getting to do work from home checklists?
Okay. Perfect. We are at time, guys. If your question was not answered, like I said, we're going to keep it. We're going to get back to you. Please take advantage of the free HR compliance and health and safety checklists. We'll try to reach out to you directly too if you're a client, just to let you know, hey, it's here if you need it. Anything else though, any feedback you have, any questions, please don't be a stranger. We love to hear from you. Service@hrcovered.com. Take care, everybody.